National President of UPMA. I am pleased to be on this evening to welcome you, along with Lisa Roussel from the Federal Long-Term Care Insurance Program from FedPoint, that oversees that program. UPMA has a partnership with FedPoint, and part of that partnership is we have agreed to jointly sponsor these training sessions twice a month. So I want to thank you for getting on and for participating, and I know that you will not be disappointed in the topic tonight: grievance handling and requests for information. That our own Jim Dunlap from Colorado, labor manager for the Colorado-Wyoming district, will be our presenter. So with that, Lisa, I'll let you introduce yourself.
Good evening, everyone. Thank you for joining. Dan, I just want to say thank you for the partnership with us. And I'm just here to, at the very end of this presentation tonight for this training, I'm just going to cover probably about 5 or 10 minutes, depending on Jim's time. But I'm just going to cover a little bit about what the Federal Long-Term Care Insurance Program is so that you can make an informed decision. I work in our education and our outreach department, and we're just out. We have a long-standing relationship with the Postal Service and multiple federal agencies, and we work very closely with UPMA as well. And so it's just a pleasure to work with all of you, and we just want you to know about the benefit. So you can apply, and so can't your qualified relatives. And if you have any questions, I have some resources that you can reach out to. So take it away, Jim.
Okay, do you need to pass me the ball?
I will pass you the ball. I think because you're a panelist, you could probably do it. You could probably take the ball from me, but I just sent it to you. So, but I think as a panelist you can. I didn't.
Okay, I will share my screen. And I'll put it in projection mode. Is everybody seeing the screen?
Yes.
Yes.
Alrighty. Thank you. So my name is Jim Dunlap. I am the Labor Relations Manager in Colorado, Wyoming for now. And I've spent a few years as a postmaster, and a few years before that as a station manager and a manager in the plant. So my passion throughout my entire career has been labor relations. I applied for that job every time it came open in the entire length of my career. It's been open 6 times, and I applied every time. And so one of those things that has always been that passion is, how can we answer the grievance when we get stuck with a grievance, and how can we really work to reduce those grievances? So the first part of handling the grievance is preparing for the request for information that you know is going to come. Every single day you have things that come up in the course of your day that create situations that make you have to make decisions about how you rearrange your carriers, rearrange your window clerks. If you have rural carriers, how you rearrange the rural carriers, and if you're in the plant, how you rearrange the mail handlers. So the union is basically entitled to anything and everything that we have that we use for management decisions. There are some very specific limitations on medical documentation and whatnot, but for the most part, everything we use to manage our day-to-day operations, they are entitled to, and it's driven by both the national agreements in Article 17 and 31 and by the National Labor Relations Act, and it's enforced by the National Labor Relations Board. So you know that you're going to get a request for information for just about any time you have to make an on-the-fly decision, and even sometimes when you're just doing everything by the book, they're still going to ask for the information just because they can. And so I'm going to ask you to create a request for information log, and you can do that if you only have a very small unit in a single file drawer next to your desk. If you're in a larger unit, I would recommend one lateral drawer of a lateral file cabinet. And you can use a variety of formats. I'm going to give you a couple of examples. But I'm going to encourage you that that as your day progresses, you keep a few notes on a daily impact sheet, just a little journal of what happened. At 10 o'clock, I had a vehicle breakdown. I had to send 2 people out to recover the mail so that I could have the vehicle towed, and exactly how your day progressed, how many call-ins you had, who you attempted to call for overtime. And there's a variety of formats. This is just an example of a log, and it's pretty simple. The date, the union, who was the requester, what supervisor has provided the information, a very brief description of the information, and the date you provided it. In a larger unit, you may want to designate one particular supervisor to handle those requests, and all of your supervisors can feed the daily file. I'm actually going to encourage you to take that daily file at the end of every day and drop it in your wherever you're filing your daily files. And before you drop it in there, make a copy of it and put it in your RFI drawer and put it on your log. So 3, 4, 6, 10 days from now, when the union comes and drops an RFI saying, I want all the information you relied on to make the overtime call on 1 May, you can go to your RFI drawer, you can pull that packet out, you can say, I just happen to have that all ready for you. Let me make a copy, give them a copy, you keep the copy right in there the way you had it set up, because in 5 to 7 days when you get the grievance, you know exactly what they relied on to produce the grievance, so you'll have exactly the same information to respond to the grievance. That happened the other day too. My mouse likes to double click. So the other thing is you got to make sure that you respond to the request for information in a timely fashion. You really shouldn't deny any information that's requested on an RFI unless you've gotten with your labor relations department, and they may even have to get with their area or now regional labor relations department to get permission to skip an item on an RFI. As you're filling that RFI, and sorry, my dog is barking in the background in case you hear it. I'm sorry about that. My wife's out there with him, so I'm sure she'll get him calmed down in a minute. Somebody must have either knocked on the door or walked by. So if you have some delays in filling the RFI as it was requested, don't hesitate to communicate with your local union and say, you know what, I've given you everything I have immediately available. I've asked for 3 copies of the Form 50, of the 3 employee Form 50s you requested, but I'm waiting on district HR to send those to me. And then make sure when you give it to them, you record it on your log that you gave it to them. So you're going to want to make sure whoever your representative is, your management representative is, that they're carefully reviewing the RFI. They research and identify any of those records that they're going to be able to provide right away. If they're asking for an exorbitant amount of information, whether it's hundreds of printed pages or hours of research, we can charge that back. We should communicate back and forth with the union in writing, because a lot of times they'll say we didn't and we did, and we need to be able to prove it. And then everything you give to them, you should keep a copy so you have it to answer the grievance. And again, they have a right to request the information, and it is enforced by the National Labor Relations Board, and we do get fines. And there are some districts that have some significant fines for failing to provide documentation or requested information. You want to avoid those unexplained delays or failures to provide the information. So if you get to the point where their request is just exorbitant, there is a provision in the AS 353 that does allow us to charge for anything more than 100 pages at 15 cents a page. There's also the opportunity to charge $21 per half hour of research time and computer time. That used to be $16 per half hour, but inflation. And and it all gets collected and gets put in on your RSS under AIC 127. And here's an example of the forms. And we will make this PowerPoint available to you. This page actually still has the $16 per half hour, but the update to the AS353 has brought that up to $21 per half hour. This is probably one of the most contentious aspects of the request for information. Is yes, there is a provision that says we get to question the relevancy of the information they're requesting. They can't go on a fishing trip. But it is very hard to argue that a 3971 for employee A, who is similarly situated as employee B, is not relative or relevant to the grievance that's being investigated. So generally, information that's requested on RFI should be provided, and then, unless you've gotten other guidance from your labor relations team. Medical records are that one component. There's this misconception that we can't release the medical records without a waiver from the employee, but the reality is that anything that we are allowed to use to make a management decision. So remember, you're not supposed to have anything that ends in an osis. No prognosis, diagnosis, thrombosis, any of those items that actually relate to the employee's actual medical condition. As soon as those are handed to you, you should send those straight to your occupational health nurse, and they will send you back a redacted message, usually through Outlook, that advises you that employee X provided documentation that limits them to 20 pounds lifting for the next 2 weeks, and that it meets ELM 364 requirements, and that you can provide to the union. But everything that we're allowed to have at the unit level, they're entitled to under the Article 1731 in the National Labor Relations Act. So now that you've provided them that information, you know they're going to go and investigate to determine whether there was a violation of the collective bargaining agreement. And you know better than anybody what happened that day, because it happened to you. It happened through you or by you. So be familiar with the information you gave them, and know if we had a violation that day. And it's absolutely okay to talk to your union president or talk to your union steward and say, you know what, today I am shorthanded and I am going to throw parcels. If they're level 20 or above, I am going to throw parcels for 2 hours. I'll put my time on a 1260. I'll log out of that. I'll sign off of that 1260 when I'm done throwing parcels, and I will provide it to you. You provide the grievance and I'll pay it de minimisly. If you know that there was a violation, work toward being ready to settle the grievance and create that communication. You know, labor management and the relationships we have really started in the 1970s. 1971 to 1973, the Postal Reorganization Act sort of reestablished the Postal Service from the Department of the Post into the United States Postal Service, and it gave the unions rights to grieve matters concerning wages, hours, and working conditions. The Postal Reorganization Act gave this idea, this expectation that we would bargain in good faith and we would observe those representatives from the collective, from the bargaining voice as the sole bargaining entity for our craft employees. So what are management's responsibilities in handling the grievances? EL 921 Supervisor's Guide to Grievance Handling. So we got to comply with those applicable steps in the grievance arbitration procedure in Article 15, and we've got to provide steward time and the the appropriate number of stewards in accordance with Article 17 and documentation, and provide postal witnesses in accordance with Article 31. Article 15 establishes a progressive layers of discipline. Each layer costs us a little bit more. So the intent is that we'll settle and resolve grievances at the lowest possible level. Step 1 are the line supervisors and designated grievance handlers. Step 2, in most cases across the country, are being handled by labor relations at the district level, although some 24 and 26 postmasters act as their own step 2s for their installations. They can do a direct appeal for things that they believe are absolutely interpretive or violations of the joint statement on violence and harassment in the workplace. Step 3, area labor relations. Some facility managers in PCs level facilities, and then headquarters labor relations. Interpretive issues go to step 4. Otherwise, things that aren't settled at step 3 go to regional arbitration, and those are either regular ARBs or expedited ARBs. I don't know why my headset just made a sound, so I hope you still hear me. For the NALC, there's an entirely different process. So you have informal A, which is your frontline supervisor and the steward. You have formal A, which is oftentimes your postmaster, maybe a station manager in a larger station. Sometimes it's even the post office, the manager of postal operations, the POOM. Then formal B is the equivalent of a step 3, and that's an area labor relations function. Again, step 4 is interpretive issues, and then they go to arbitrations, regional, national, and regular ARB or expedited ARB. We have time limits, and we should follow those time limits, and we should argue those time limits. And in the national contract, they're outlined very very specifically in Article 15. Those timelines are outlined in the NALC and in the NRLCA as well. And one of the very best arguments in your grievance process is if it's been 18 days since the incident occurred, or the union should have been relatively aware that the incident occurred, you should argue that it's untimely. And those time limits are in calendar days. It doesn't matter if it's a work day or not. So a couple things to think about that will be sure fatal flaws in your process. Every single person who's designated to handle a grievance has the authority to settle the grievance. So any one of us that's in an operational position can settle the grievance. You have that authority. We make command and career decisions each and every day. So it's a step 1 informal A. It's a discussion between that supervisor and that steward. Step 2, installation header designee. The union also has to designate a step A representative or a step 2 representative. And at step 3, it's usually an area labor relations specialist and a national business agent are the parties involved. And again, never want to present it as, oh, well, I don't have the authority to settle that. I can't unrevert that bid. I can't pay that day of active God leave. It's beyond my scope of authority. Handling the grievance is part of our day-to-day operations. In fact, in the new stovepipe structure, the intent is all grievances will be handled at step 1 and step 2. Very few grievances will get referred to step 3, and even fewer to arbitration. That's really in an effort to try to curb the cost. Step 3 and especially arbitrations cost us a great deal of money. About $500 in management cost at a step 3 grievance, and about $5,000 if we have to pay the whole fee at arbitration. Otherwise, if we split the fee with the union, it's about $2,500 to $2,700. So, and the consequence for not answering those grievances when they get presented to you, and a lot of frontline supervisors like to just say, oh, send it up. that consequence is you're going to get a grievance again tomorrow, and the next day, and the next day. And grievance payouts show up on line 44 of your total operating expense on your TOE on your flash. And the best way to have control of the outcome of the grievance is to settle it at your level. Once you pass it on to the next level, you lose a lot of the control of how it's settled. An employee or their bargaining voice has to discuss the situation with a frontline supervisor, the employee's immediate supervisor, within 14 calendar days. If it's beyond 14 calendar days and you haven't given an extension in advance, your very first argument should be that the union was untimely in the prosecution of their grievance. If that step one grievance affects more than one employee, it'll be called a class action, and there should be a designated management representative to handle class action grievances. So one of those first things you do in handling the grievance when it's handed to you or presented to you is you first determine that the steward who presented it to you is certified for the facility that they're trying to represent. And secondly, that it is timely. You want to determine any and all things, procedural issues. Was it a jurisdiction? Was it an RI 399 issue? Was it work that belonged to the mail handlers or work that belonged to the clerks under RI 399? Was it a light and limited duty from rural carrier acting as a clerk because they're on limited duty for an on-the-job injury? And one that's more prevalent with the NALC, but also has started to crop up in the APWU, is an alternative dispute resolution process for conversions in accordance with the MOUs on filling vacant career positions, either by conversion or by e-reassign. You got to make sure that all the requests for information that were requested in support of that grievance are fulfilled. Otherwise, it will go up to the next level, and very often it'll get remanded back to the level below to fully develop the case. And so you might have a finance supervisor or a supervisor who focuses on your window and distribution, and a supervisor who focuses on your carrier operation. They both might have information independently that supports the situation for the grievance. You want to make sure you talk to anybody who could have been involved. 5 days. 5 days after they present the grievance to you, you have to give them an answer, and that answer can be denied. But if you deny it, and it's a clerk or rural carrier, you're going to fill out a 2608, you're going to send it to labor, and you're going to provide or to your step 2 designee, and you're going to provide a copy to the union at your step 1. If it's a NALC, you're going to schedule a meeting at Informal A to discuss it. You're going to want to gather all your information. You're going to go right to your RFI file, and you're going to pull the date that they're grieving about, and you're going to have the whole stack of information that they have about the day as well. And to make sure that that steward is certified for the unit and the pay location. So there are times when we act appropriately within the contract and they could still file a grievance. And when we file that, when that grievance goes up through the chain, that grievance could still get settled even though we acted appropriately. And it's unfortunate, but yes, there are times in the labor practice where you have 6 grievances all with the same steward for relative situations, and they pile together, and one that might have been defendable or defensible ends up getting settled in the provisions with the other 3 or 4 grievances. So you're going to want to review the applicable JSIM and JCAM And another thing that has impact is your local memorandum of understanding. Really, the relationship between that unit steward and that unit manager does not have to be confrontational. It can actually be working together. And a lot of times that getting past that contentious relationship, getting into a harmonious relationship, gives you the opportunity to interact and avoid grievances by actually, you can take your holiday schedule to the president and say, I'm about to post my holiday schedule. Want to take a look at it quick, see if there's anything that we've done out of line, and we'll work to try to resolve it before it becomes a grievance. And so in that meeting, you want to be honest, you want to be interactive, you want to practice some active listening skills. What I think I heard you saying is, and then, if the union's position has merit, admit it, correct it, try to mitigate the liability to the lowest possible level. It's a two-way street. Sometimes we have this idea we know we're right before we ever sit down, so we're not listening to what they're saying. Try to ask relevant questions so that you can understand their position. They will do the same and try to understand your position. The more open and engaging you are with them, it's kind of like a mirror. They see it, they reflect it back at you. And at the table, management and union representatives are equals. So you are both empowered to settle that situation, resolve that grievance, and try to come up with what the contractual provisions were and what the remedy is or should be. And remember, in the remedy, we're only trying to restore the status quo ante. We don't have to pay $100 stipend on top. We shouldn't be paying excessive iterations of stipends, 50%, because it was a bypass situation or a backfill situation. There are units that get up to 150, 200, and 300%. We don't have to pay enhanced or punitive stipends. We are bargaining in the grievance process to restore the status quo ante. So both the union and the management make their full and detailed statement of what they believe the facts are. You work through the disputes, try to resolve it at the lowest possible level. And you don't really want to get in the habit of contradicting the contract, and the joint contract interpretation manuals and the JCAM, the JSIM are very, very helpful in that process. Always bargain in good faith, listen to the union's full and detailed statement, give them your full and detailed statement, and if the position has merit, go ahead and enter a settlement. So this is where we get into a little bit of the fear factor for management personnel. The step one grievance is the one place where you, the frontline supervisor, manager, or postmaster, have your hands on the company checkbook with very few checks and balances. It's the one place where we can write checks and there's not a lot of oversight unless there's an audit because you happen to pay $40,000 out to the same employee through 16 settlements this year. There could be an OIG investigation. And so your written supporting documentation that identifies why you paid what you paid or supports your decision for why you denied settling the grievance that will become the arbitration record are very important, and they are auditable. You should keep your decisions in a full statement, all relevant facts, contractual provisions, the detailed reasons for the denial of the grievance, the detailed reasons for the settling of the grievance. Strive to resolve those grievances anytime you can. In the new structure, in the new stovepipe, 90% of grievances will be settled at step 2 or below. Very little will go above. And if you need some help, reach out to labor relations. There'll be a person who's assigned to your geographic area as a labor specialist And unfortunately and fortunately, labor happens to be one of those jobs that really takes a person who has a passion for the position. And as a result, they'll probably answer their phone 24/7. The JSIM and the JCAM, it helps to identify what the intent of the contract was, and it incorporates arbitration settlements that have helped to define the intent. Your grievance situation is not about personal opinion. It's not about personal interpretation. It's about that defined contract law and the arbitration settlements and the agreements between management and local unions. Always reference the citations out of the JSIM and the JCAM, national grievance and national agreements in your settlements. I can't tell you how many times I see extensions that are just carte blanche extensions. Extensions on the grievance timelines, especially on a disciplinary action, should be the exception and not the rule. Okay, so my thing said that I have mute on again. You guys still hearing me?
Yes, we are.
Okay, cool. So they should be in writing, they should be dated, they should have the grievance numbers, the exact grievance numbers that are being extended, why they're being extended, and how long they're being extended, and they should be signed by both parties. You're going to maintain and organize your filing system so that when you're audited, you can go right to the file that they're asking about. The more organized and detailed you are, the less files they will look at in an OIG audit. You demonstrate that they ask a question and you know exactly where to go to get it. They might ask that twice and then they'll say, okay, you're good. If you got to look for 16 different drawers and 9 different files to find the first grievance that they ask you about, they'll probably look at 100. You should never look at handling the grievance as a nuisance. It's part of our duty, and it really is intended to give us a chance to identify where we're violating the contract so that we can improve tomorrow. The grievance designees, make sure that you receive the benefits of it's a bargain. You know, management receives the benefits of it's a bargain. We have made a commitment, and the union has made a commitment of how those employees will operate. We need to honor our commitments, and we need to hold the employees accountable for honoring theirs. Step 2 is the last opportunity for either side to enter information in that will be used to put on an arbitration. That the complete file has to leave step 2, and very seldom can you get anything else added after that. Exercise that authority you have to settle grievances. That designee has the responsibility to settle the grievance, and they have the authority to settle the grievance. I've left a little bit of time for questions, and then I'll turn it over to Lisa. If you type a question in the chat box, I think I can get to the chat box. I think.
And I can look at the chat too, Dan. I mean, Jim. I keep calling you Dan. I'm not seeing any questions. Are you seeing anything?
Nope, I'm not seeing anything in the chat box. I'm going to go ahead and stop sharing and turn it over to you, Lisa.
Thank you so
Thank you,
much, Jim. Share my content here. All right. So as I said, I'm here just to talk simply about the federal long-term care insurance program, and I'll just start my video here so you can see me. those of you who, some of you who are on this training tonight may already have the federal long-term care insurance program, the FELTSIP, but just know that this is FELTSIP 3.0 that I'm just talking about, and I'm just going over the highlights. Federal employees, U.S. postal employees, they are all eligible to apply for this coverage, and you can apply at any time. It's not just an open season benefit, and I just want to make sure you understand that. A lot of people think it's just during open season, so really you can apply for this coverage at any time. So let me just kind of talk a little bit about, I'm just going to try to, my slides are not advancing here, so it takes a little bit. Okay, so what is long-term care? Some people have a preconceived notion, and again, I'm just going to go through a few slides, but what long-term care is, it's not skilled medical care. So we're not talking about the care that like you receive when you go to the doctor's office or the hospital. It really follows the activities of daily living. So just think about it this way. If you couldn't perform 2 activities for daily living for 90 days or more, and they're listed here, or if you suffered from a major cognitive impairment like Alzheimer's, that would constitute a long-term care event. What I tell everyone is to remember that it doesn't matter why we ever need assistance with these activities of daily living. Remember, the need for long-term care can arise at any age or for whatever reason. It could be from an accidental injury, an illness, a chronic illness, a disease, or simply the aging process. The reason why we talk about long-term care is because today's reality, people are living longer. That's wonderful. The longer we live, the higher probability that we're going to need some sort of care at some point in our lives. And as I always say, it's not a matter of if, it's a matter of when. And what we're talking about is custodial care. That's what we're talking about. You don't need a medical provider, a doctor or nurse to take care of you when it's custodial. So help with those, bathing, dressing, eating. And one of the things I always like to mention here is that the cost of a long-term care event can quickly derail your retirement. Those of you who have been working for the post office for years, you probably have your estate plan, your financial plan. What is your long-term care plan? Have you had a discussion with your family members? Some people think their children are going to take care of them. Nowadays, that doesn't really happen, but having that discussion with your children and who's going to pay for that care? And what services are you going to call upon? So this is the federal long-term care insurance program. So what are the benefits that don't cover long-term care? Just remember that disability insurance doesn't cover long-term care. It's really there during your working years, and it's income replacement. The FEHBP, you all have the FEHBP. I too, I'm married to a federal employee, so I have the FEHBP. It doesn't cover anything like we're talking about custodial informal care. It covers acute diagnosable conditions that we either recover from or stabilize from. Medicare, there is a rehabilitative benefit on a short-term basis, and it is subject to restrictions for those people that are eligible for Medicare. When you're thinking about long-term care, you want to think about what are the costs going to be, not only in today's cost, but what are they going to be in the future? And so we have a cost of care calculator. Highly recommend it. If you're thinking about long-term care, if you're just interested, go to ltcfeds.com. There's a cost of care calculator because the costs vary across the country. So when you're designing a plan, and that's the beauty of this program, you can design this program to best meet your own personal and financial needs. You want to think about where are you going to live and how much is it going to cost if I age in place. Most people want to age in place. They want to be at home. They want to be cared for by loved ones. There's higher efficacy. There's better health outcomes. What we saw with COVID, a lot of people, came out of nursing homes and came home. So it just really depends. The beauty is you can go to different places. You can go to skilled nursing. You can go to a nursing home, You can go to a assisted living facility. You can age in place, as I said. So look at those costs. Home care costs. These are national costs, just so you know. And this is for 5 days a week for 5 hours of care. Anyone who's ever cared for a loved one, I lost my mom 2 years ago, you know that care isn't just a few hours a day. It may start out like that. It may start out with instrumental activities of daily living. So maybe somebody needs assistance with shopping or cleaning their home or paying bills. Then it progresses and it gets to be at a point where people are caring for their loved ones and it gets to be 24/7. Generally, we start to see bathing as one of the first ADLs to be compromised, but you might see dressing. And so when that happens, that's when people turn for outside care. So that's something to really think about because when 24/7 happens, it's exhausting. So look at the costs. You can see what those costs are. And you can look at a nursing home in Phoenix, Arizona compared to San Francisco. Maybe supply and demand, there's more nursing homes in Phoenix, but just know that those costs vary. In terms of the FELTSIP, how can it help you? Well, one, it protects your enrollees' retirement plans. If you want to leave money to your heirs, it really behooves you to probably have a plan. It allows enrollees to stay home as long as possible. As I said, most people want to age in place. It reduces family members' stress. Remember that caring for a loved one is one of the most stressful life events, and it facilitates informed decision-making every step of the way. This is what we cover in terms of coverage, comprehensive coverage. You can age in place at home, adult daycare center, assisted living facility, nursing homes, and hospice facility. And that's the beauty of the program. In terms of the strengths of the program, it's the largest employer-sponsored long-term care insurance program in the country. It's underwritten by John Hancock Life and Health Insurance, and it's sponsored by the U.S. Office of Personnel Management. So your FLTCIP benefits or the FLTCIP premiums are in an experience fund separate from John Hancock's other assets. And we just paid over $1 billion in claims, and we're there to pay your claims. So, you can rely and know that we're there. We have high performance metrics to meet as well. And remember, in terms of eligibility, it's federal and U.S. Postal Service employees and annuitants are eligible, active and retired members of the uniformed service. And here's the takeaway for those of you, and for those of you who may dial in and listen to this recording at another time. Qualified relatives can apply for this coverage if you don't apply. This is a medically underwritten product. In other words, there are insurable and uninsurable conditions, and some people just simply won't get into this program. So even if you don't get into this program or you're not interested, share this with your qualified relatives. So your current spouse, your domestic partner, your adult children age 18 and older, your parents-in-law, and step-parents of employees and active members of the uniformed service. When you retire, your parents-in-law, and step-parents are not eligible. So if you're thinking of having them apply, you want to do this while you're still working. And then, of course, a surviving spouse receiving a survivor annuity or a basic employee death benefit would be eligible. As I said, coverage details, premiums are based on your age at the time of your application. Age is the #1 determining factor when people apply for this coverage. What we see with the federal long-term care insurance program, as I say, the FLTCIP, the average age is about 52 to 53. We're starting to see that come down a bit. But remember that every year you get older, it gets a little bit more expensive to apply. So when you're thinking of applying, I would encourage you to apply before your next birthday if you're thinking of applying. As I said, it is medically underwritten, so there's insurable and uninsurable conditions that may prevent you from getting in. When I talk about uninsurable conditions, I think of like Lou Gehrig's disease, MS. There's a various diseases, but if you're already needing assistance with some of those activities of daily living, that would be an automatic disqualifier. Coverage is fully portable. It goes with you wherever you go. So if you decide to leave the country or you decide to leave the Postal Service, as long as you continue to pay your premiums, it's guaranteed renewable. And as I said, qualified relatives can apply even if you don't apply. There's resources that are available. Go to 1-800. You can call and speak with one of our program consultants, 582-3337, or you can certainly go to our website. There's lots of great planning tools. There's premium rates, there's brochures, and there's applications there. So with that, I want to thank you so much for your time and attention tonight. As I tell Jim, it's past my bedtime at 9 o'clock, but it's a privilege and an honor to be here with all of you. So if you have any questions, please feel free to call the 1-800 number. We have fabulous program consultants, and they're there to assist you. I'll turn this back to Dan.
Thank you, Lisa. Thank you again, Jim, for your presentation tonight. Thank you, everyone, for getting on. And with that, we're going to get off here just a little bit before the hour is up. So again, thanks, everyone, for being on, and enjoy the rest of your evening. Good night, everyone.